If one does an act and he knows, or by the exercise of reasonable foresight should have known, that injury may result from his act, the act committed is negligent and will be deemed to be the proximate cause of the accident or injury. Those who are engaged in transmitting high voltage electricity are required to exercise a degree of care to guard against injury, and where the operators of electric power maintain high tension wires at places where workmen and people might rightfully be, it is the duty of such distributors of electricity to provide effective insulation as well as other safeguards, but they are not required to provide insulation or safeguards where they have no reason to expect that people will go. Now, the plaintiff's decedent, Felix J. Schroeder, was also required to exercise due care under the circumstances for his own safety. The danger of electrical energy is a matter of common knowledge, and all persons are held to a certain minimum of knowledge common to the community. Now, the question is not what a person does know about electricity, but what the law assumes that he knows. A person of ordinary intelligence is assumed to possess such scientific knowledge about the dangers of electricity as is common among laymen in the community. If a person recklessly exposes himself to known or imminent danger unnecessarily in a manner that a person of ordinary care would not do under the circumstances, he assumes the risk of such danger and is guilty of contributory negligence and cannot recover for any injuries sustained by him under such circumstances. The same rule applies if some other person brings suit for his death. This is one of the important questions in this case. Was the deceased guilty of negligence which either caused or contributed to cause this accident? The plaintiff cannot recover any damages in this case if, at the time of the accident, her husband was himself negligent. That is, if he failed to exercise reasonable care for his own safety, such care as men of ordinary and reasonable prudence usually exercise under the same or similar circumstances, and if such negligence was a substantial factor or a material element in causing the accident. The first question that you will take up and determine when you retire to the jury room is whether the defendant, the City of Rogers, was negligent in the manner and as claimed by the plaintiff. If you fail to find from the preponderance of the evidence, that is, by the greater weight of the evidence, that it was negligent in the respect claimed, then you need consider this case no further. But if you find that the City of Rogers was in fact negligent, then you will consider whether or not such negligence was the proximate cause of the accident. The burden of proof rests upon the plaintiff to prove by the greater weight of the evidence that the City of Rogers was negligent and that its negligence caused the accident in question. If on this question of the defendant's negligence, you find the evidence evenly balanced or preponderating in defendant's favor, then you will find a verdict of no cause of action. Ready? 200 jury charge number 1. Mr. Foreman and gentlemen of the jury, it is the claim of the plaintiff, the administratrix, that on the 5th day of October, while the plaintiff's intestate was crossing from the northwesterly corner to the southwesterly corner of Division Avenue, she was struck by the defendant's trolley car and received injuries, which resulted in her almost immediate death. The plaintiff alleges that the car of the defendant at the time in question was operated in a careless and reckless manner at a high and improper rate of speed, that no warning of its approach was given, and that the brakes of the trolley car were insufficient and out of repair. Those are the allegations of the complaint. The defendant disclaims any liability, denies that its car was operated in a negligent manner, and claims that whatever injuries the decedent may have received were caused by reason of her failure to exercise due care and diligence and were the result of her own negligence and carelessness. Each side has presented its testimony, and the questions of fact raised by them, you gentlemen, are now called upon to determine. The court directs you, before going any further into this charge, to disregard any appeal that may have been made to you by way of rousing your prejudice or instilling into your minds any bias. If you did not, you would indeed be unworthy of your citizenship and, in fact, to sit as jurors over the affairs of your fellow men if you would be in any way susceptible to any such appeal. You must not have any sympathy because the plaintiff's intestate was a woman. You must not have any bias or prejudice because the defendant is a corporation. You are called here to hold evenly the scales of justice, to do exact justice, and to be determined to render justice between these parties. This action, gentlemen, is what is known in law as a case of negligence. In every negligence action, there are two questions to be considered. Those two questions are first, that the defendant was guilty of negligence which caused the accident, and secondly, that the plaintiff's intestate, this old lady, was free from negligence contributing thereto. Why should that be? For the reason that the law does not allow a person to recover damages from a defendant for injuries if the negligence of the person injured has contributed to bring about the injury, because one cannot recover under our law for injuries which he or she has been instrumental in bringing about, so that it does not make any difference how negligent the defendant may have been if the plaintiff's intestate was guilty of contributory negligence. Now, as a rule, gentlemen, in negligence cases, the burden of proof is on the plaintiff to establish both the defendant's negligence and her own freedom from contributory negligence. It is not so in this case, for the law provides that on the trial of an action to recover damages for an accident causing death, that contributory negligence of the person killed shall be a defense to be pleaded and proved by the defendant, so that in this case, the burden in that respect is removed from the plaintiff and is placed on the defendant, who must prove contributory negligence on the part of the decedent. Now we approach a consideration on your part of the rights, duties, and obligations of these parties. Before the plaintiff in this case may recover against the defendants, it is incumbent on the plaintiff to prove to your satisfaction that the motorman in charge of the car that injured this old lady, as the result of which injury she died, failed and neglected to exercise ordinary care and diligence in stopping the car in time to have avoided injury to her, and unless the plaintiff has shown by evidence that there was lack of ordinary care on the part of the motorman, then your verdict must be for the defendant. In other words, the plaintiff must show that the motorman, after he saw or by the exercise of ordinary care might have seen danger to her, was guilty of carelessness or negligence in failing and neglecting to stop the car in time to have avoided injury to the decedent. The obligation resting upon the defendant motorman was to exercise that degree of care which a person of ordinary prudence, exercising reasonable care, would use under similar circumstances. If you find that the motorman exercised such care, then the plaintiff in this case cannot recover. If you find the trolley car was operated at a high rate of speed, that is evidence of negligence. But this alone would not be sufficient to charge the defendant with liability. It is to be considered with all of the evidence in the case in determining whether the woman's injuries, as a result of which she died, were caused solely by defendant's negligence. If she in any way contributed, in any way participated by her conduct, by her lack of diligence or care, then you cannot find a verdict for the plaintiff. The motorman of a trolley car must keep a reasonable lookout along his intended course and is liable for injuries inflicted on others if the danger is observed or might have been seen or have been avoided by the exercise of reasonable care. 200, jury charge number 2. Gentlemen of the jury, the testimony in this case creates a situation which by due course of your service here has familiarized you with some of the rules of law that become applicable in this type of case. However, each individual case must be decided on its own merit, and for that reason the court is not allowed, even though it realizes your familiarity with some of the principles to which I will direct your attention, to avoid the application of all the principles of law that arise under circumstances of this kind. I therefore call your attention to the application made by counsel for the defendant both at the end of the plaintiff's case and again at the end of the defendant's case to dismiss this complaint and the denial of those motions by the court. You understand, gentlemen, that such denial has nothing to do with you at all. It only means that the court has resolved that sufficient facts have been presented, which, under the law, I am compelled to put into your hands for examination and determination. You are to take no particular significance as to the merits of this controversy, because of the rulings made by the court on those applications. You understand fully that it is the function of the court to give you the law that arises in a particular case, and that it is your duty to accept that law, whether it be pleasing to you or not, because if the court be in error in the application of any principles, counsel may take an exception to my rulings, and that exception protects them in a higher tribunal, which would pass on any appeal that may be made. So with the same force and effect do I call your attention to the responsibility which the law places upon you of testing truth, credibility, and the probability of testimony that is given to you from the mouths of witnesses. Of course, it is the duty of counsel to ask questions, and they become a part of the record just the same as the answers given by the witnesses. But the determination that is to be made on issues of fact by you is not to be taken from what counsel or the court say the testimony was, but from your own recollection of what the witnesses themselves say. That is from where you will take the truth and the credibility of particular stories which are told to you. To aid you in doing this, the witnesses, when they are placed on the witness chair, are not turned to the judge. They are turned to you, because that affords you an opportunity of scrutinizing the whole demeanor of a witness. And the reason is logical, for it enables you to use that same common sense and judgment which you use in the course of everyday circumstances and everyday business affairs, in here testing the truth and credibility of what the witnesses say here on the stand. This action is based on what is known in law as negligence. Negligence, in its simplicity, means the failure or omission to use reasonable care in the performance of a duty which one owes to another, and which is found to be the proximate cause of the accident resulting in injury. This plaintiff's contention, therefore, must stand or fall on the elements upon which she contends that she was burned in this beauty shop operated by this defendant through its respective servants or employees or agents for whose acts they stand responsible. Her contention is that on the 2nd of June, which was the second visit to this beauty shop, she received the burn which she has described, and in the course of the application of this treatment of a permanent wave, they failed to exercise the degree of care of ordinary prudent operators, in that they failed to put these two pads under the particular iron wherein the heat was contained, resulting in a burn upon the forehead. Her contention is corroborated by the young person who was with her at the time she was in this shop. As distinguished from that proof, you have the contention made by the defendant to the effect that this young woman called at their place received a permanent wave, and that at a subsequent call, she said that it was not satisfactory. Further, upon a thorough examination made by the defendant to determine whether a proper wave had been made, she made an examination of her hair and discovered what appeared to be a burn on the forehead. That creates two different stories, gentlemen, because they are diametrically opposed to each other. The contention of the plaintiff being it was on this second visit to the shop that this burn was made upon her head, as contradicted by the defendant's contention that it was upon the second visit that they noticed the burn upon her head. So you see, these two stories cannot be reconciled. Therefore, the responsibility is upon you of testing first the issue of fact as to whether or not she was burned in this shop, and secondly, whether or not she was burned at this second visit when the new permanent wave was being applied. Okay, next. 180. 180, jury charge number 1. Ready? Gentlemen of the jury, on Sunday afternoon, August 19, 1994, the infant plaintiff in this case received personal injuries while a passenger on defendant's car. He is suing through his father, guardian ad litem. He claims that his injuries were caused solely by the negligence of the defendant, which in this case would be the conductor or motorman or both of the trolley car. And the father also claims that the injuries were received without any negligent act of the boy contributing to it. The defendant denies these two claims. The plaintiff's claims and the defendant's denials constitute the two issues in the case which are being submitted to you for determination. The word issue simply means a dispute, and to determine the issue means to make an end of the dispute. It immediately occurs to you, how are you going to do that? It can be done in only one way. It cannot be done under your oath by speculation, by flipping a coin, so to speak, by allowing your sympathies to enter into your verdict. I shall not say to you that you should not have sympathy. Now that would be ridiculous. Any red-blooded man would have sympathy for a boy in the plight that this boy is in. But I do say that you are not permitted to allow your sympathy to enter into your verdict, either in finding in favor of the boy or having found in favor of him in the amount of the award. The one way which is left to you to determine these issues, that is, to make an end of these two disputes, is by applying the rule of the preponderance of the evidence. Those words must be familiar to you if you have sat in other cases, but we always have to repeat them and explain them in each case. They refer not to the number of witnesses nor to the volume of the testimony, but rather to the quality of the testimony. There are a few tests which you may apply in judging the quality of the testimony. The first is the rule regarding interested witnesses. Of course, the boy's father and mother in this case are interested witnesses as a matter of law. So also are the witnesses presented by the defendant who are now in the employ of the defendant. You do not have to pass any time in determining whether these witnesses are interested, because the law holds that they are interested. It is for you to say, however, whether any other witness that testified in the case is interested as a matter of fact. But even then, it does not follow that because a witness is interested, you are to disregard his testimony entirely. It follows only that you are to take note of the interest and judge for yourselves how much value is lost by reason of the interest. Another test to apply in aiding you to determine the quality of the evidence is the rule regarding false testimony. There it is more severe. If you find that any witness on either side has testified deliberately falsely to any material fact in the case, then you are free to disregard all the testimony of such a witness. And then there is the test of probability, the common sense test, which you will know how to apply without any instructions. After you have selected in this way what you regard as the credible evidence in the case, then place the evidence, so to speak, in the scales of your minds. But at that point, remember that the burden is on the plaintiff. That is the law, no matter how harsh it may seem. The burden is on the plaintiff to satisfy you by this preponderance of the evidence that his injuries were caused through the negligence of the defendant's servants without any contributing negligence on his part. Very briefly outlining the plaintiff's testimony or claim, it is that the boy was on this northbound trolley car, and when it reached 9th Street, the boy stood up and indicated to the conductor of the car that he wished to alight to get off of the car. He was in a seat on the right hand, about midway in the car. It was an open trolley car. The boy says that as he stood there facing out, his right hand on the brass rail of the seat upon which he had been sitting, and his left hand on part of the seat to his left in front of the car, which was in motion in the process of slowing down, jerked violently, and that the motion threw him off the car. He further says that the conductor saw him when he indicated his wish to leave the car, and he walked on towards the front of the car on the running board, leaving the boy behind him. That is not all of the plaintiff's testimony, but that is a very brief and incomplete outline of it. According to the defendant's version of the manner in which the accident happened, the boy stood up at or about 9th Street and indicated his desire to leave the car. (180) Jury charge number 2. Gentlemen, gentlemen of the jury, what I want you to do in this case is to use your common sense. You have heard a brilliant array of doctors and other witnesses and the eloquence of the lawyers, but yours is the responsibility to decide this case. Talk about justice. There is no justice known here except justice in accordance with the law. If we obey the law, we will be doing justice. I am the law to you. If I make a mistake in the law, these lawyers know how to correct me. It is a much more difficult thing to correct a mistake that you make, but if you follow my instructions, you will be doing your full duty. And so far as you depart from my instructions, you are false to your duty. While the case from the plaintiff's point of view is a serious one, yet the evidence is not so difficult. There are two branches to it, as the lawyers have said. First, who caused the accident? The plaintiff must prove that he came to his initial injuries that he received because of the happening of this accident, that he received those injuries through the negligence of the defendant, and he must go further and provide that he himself was wholly free from negligence contributing to the accident. The burden rests upon the plaintiff. He is here asking you and me to give him a very large sum of money, take it away from the defendant and hand it to him. The law is that the person asking the money of another, that it be taken from somebody else and handed to him, has the burden of proof. He must come in here before judge and jury and prove his case, as the law puts it, by a fair preponderance of the credible testimony, that is, testimony which appeals to your minds when viewed in the light of your common sense and practical experience as being more worthy of belief than the opposing testimony. When the testimony on behalf of the plaintiff is put in the scales as against the opposing testimony, the plaintiff's side of the scales must fairly outweigh, not in number of witnesses, not in mass of testimony, but in the quality of the testimony. Do not hope that you can reach certainty. There is almost nothing certain in this world if you will stop to think about it. You gentlemen do not know what time you are going to get home tonight, and you do not know whether dinner will be ready for you on time either. Nevertheless, these controversies must be settled or society would break down. Men would be taking the law in their own hands. This is the tribunal ordained by the Constitution and the laws for the settlement of these disputes, and I charge you that it is your duty to exert every reasonable means to reach an agreement, so that when we get through with the case, there will be an end of it, and justice done so far as we are able to do justice. If we do that, we will have done our full duty. The testimony is quite simple relating to that accident that occurred. You have seen the witnesses all in this chair. You have heard them under direct and cross-examination. You noted their appearance, their manner of testifying, and the story they told. How did it impress you when viewed in the light of your good old common sense? Where in all reasonable probability does the truth lie? How did this accident happen? The burden of proof is upon the plaintiff. He must show that the accident happened through the negligence of the defendant. He may show that by a fair preponderance of the credible testimony. He must further show that he himself was wholly free from negligence contributing to the accident. That he must show by a fair preponderance of the credible testimony. No matter how negligent the defendant was, if his negligence contributed in the least degree to the accident, he cannot recover. Now consider the testimony bearing upon the accident, all of the testimony. You are not obliged to believe nor to disbelieve a single witness that has testified from that chair, if the testimony does not appeal to your minds when viewed in the light of your common sense as being worthy of belief. What we are after is the truth, so nearly as we can get it, as I said before, and shall say again, because I want to drive it into your minds, the truth. Of course, unless the plaintiff prevails upon that first branch of the case, he has lost entirely. Your verdict will be for the defendant. Naturally, we sympathize with this man. We would be inhuman if we did not. We can be just as sympathetic as you please, but you must be sympathetic at your own expense. There is no law forbidding you from going into your own pockets in order to show the goodness of your heart and how sympathetic you are by the size of the bill you hand out to the object of your sympathy. But do not vote somebody else's money to the object of your sympathy to show what good fellow you are. Came up a lot, didn't it? Towards the end. Okay, so let's go to the party, see if they need any help. 204 voice for 15 minutes. Starts with question by defense. Okay, ready? Starts with question by defense. And did you contemplate that to be a long-term investment, at least $100,000? Yes. And then you withdrew that money a few months later, did you not? A couple of months, yes. Why did you take out the $100,000? Arlen said he needed more of it for construction and he couldn't wait. Mrs. Wayne, wasn't it because you decided that you didn't trust that financial institution any more than you trusted a bank, and you felt more secure investing your money in property? No. It wasn't? No. Had you planned to buy the apartment and the other parcels of property prior to you withdrawing the cash? No. You didn't? I don't think so, no. Well, when did you withdraw that cash from the funds? I don't really know. I don't remember. It was withdrawn before Richard was paid his money for the property. Let's reconstruct when it was withdrawn. Now, there's an exhibit. Can you help me, Mr. Histon, speed things up? Yes, there's an exhibit, Exhibit 15. Exhibit 15 or 16. To speed things up a little bit, Mrs. Wayne, the bank statement, your bank statement on the Bank of America account number 16 exhibit indicates that that money was deposited into the account, $90,627 on April 11, 1986. April 11, 1986. April 11, let's keep that date in mind. All right. Now, the money hit your bank on April 11, 1986. On March, if you look at your schedule, check number 548, on March 25, 1986, you wrote a check for cash, which you made a notation was for the Maple Street property. Which check number is this? 548, yes. Now, how long had you been looking, by the way, the 174 Maple Street, is that the apartments or the two houses, the first property purchased? How long had you been shopping for that property before you bought it? Not very long. I spotted it right away, about a week. About a week.